Now, James Melendres is going to explain that there are only two types of companies, those that have been hacked and those that have not been hacked yet. In addition to defending the networks from ever-present cyber threats, companies face formidable related legal challenges. James is with Snell Wilmer. He's a former DOJ attorney and a representative to the National Cyber Investigative Joint Task Force. He is going to discuss steps that companies should take to comply with cybersecurity-related regulatory requirements and to investigate and mitigate an attack and prepare to defend inevitable post-attack litigation. Please give another warm welcome to James Melendres.
Thank you, Jesse. Good morning, everybody. I'm going to speak today about what companies and their counsel need to do to prepare for the inevitability of cyber attacks and the related inevitability of litigation that stems from those attacks. And effectively managing cyber risk in today's world is complicated, not just from a technical perspective, but from a legal one as well. And going forward, that challenge is only going to increase in terms of complexity and sophistication. Sorry. So, to start with, the challenge is difficult because in addition to being responsible for defending their networks from rapidly evolving, increasingly sophisticated cyber threats, companies also face at least three categories of formidable legal challenges, and I've listed them on this slide. The first, a legal challenge that arises before a breach ever occurs, and that is the growing cybersecurity-related regulatory requirements. Cyber preparedness is also a part of this. Immediately after a breach, moving to the second category of legal challenge, is rapidly responding to the breach, investigating it, remediating it, defending the network, and doing so in a way that maximizes the protections afforded under the attorney-client privilege and the work product protections. And then third, defending a company, your client, against what is inevitably going to be litigation following a breach, whether it's class action litigation, shareholder derivative litigation, or some type of private litigation among vendors or third parties. So to start with, let me just give you the landscape of cyber threats from a 30,000-foot view. Jesse had it basically right. It's actually a little bit worse of a situation, which is there are two types of companies. There are those that have been hacked and those that don't know they've been hacked. And you don't need to take my word for it because both the former FBI director, Robert Mueller, made the point, and the current director, James Comey, did as well. Now, the FBI has reorganized itself to partner with the private sector in addressing the myriad challenges confronted by companies with respect to these cyber threats. And recently, when Director Comey was speaking about that new partnership, he outlined 5 different categories of threat actors. And so this is helpful context for thinking about the legal challenges that we face in this space. So just let me tick through these. First of all, they're nation states. The primary ones, as outlined by Director Comey: China, Russia, Iran, and North Korea. There are government budgets that are dedicated to sponsoring these attacks. They focus on companies across the United States in every sector and every industry, and they look to, through cyber-enabled means, steal intellectual property and confidential business information. There are also multinational cyber syndicates. Think about Eastern European organized crime. These individuals are involved and these organizations are involved in the theft of personally identifiable information, credit card information, the resale of that information on the black market. You also have purveyors of ransomware, hacktivists who commit computer intrusions for a variety of motivations: political, social, ideological, and then on some levels, the most concerning, terrorist organizations are involved in computer intrusions, exploiting data for particularly dangerous purposes. Now, those are external threat actors, but for companies and organizations, including law firms, another significant threat are insiders, those individuals who have access to networks, to shared drives, to directories, who exploit that access for bad purposes and can pose significant risks to a company's ability to function. Now, those are the threat actors, again, from a 30,000-foot view. What are the particular dangers that we need to think about preparing for, both from a technical perspective and from a legal perspective? And next to the shadowy-looking cyber guy, I've listed a few of them, and they include the theft of confidential business information and proprietary technology. Again, typically, this threat is sponsored by nation states who are looking to leapfrog years or decades of research and development. You have destruction of information and systems. In some ways, this is the worst case scenario for a company. This is what happened to Sony Pictures a couple of years ago when they were attacked by North Korea. And this is not even just ransomware. This is destruction of computers, servers, networks. It's what's called bricking, because your computer is nothing more than a brick when they're done with it. And this is all perpetrated from oceans away. There are DDoS attacks. This spring, the Department of Justice returned an indictment against several Iranians who were responsible for DDoS attacks on the financial industry here in the United States in 2013. Website defacements, malicious activity by hacktivists, and then cyber-enabled financial crimes and other frauds. So one particular strand of this type of financial crime, which is on the rise right now, is what's called business email compromise, and we can talk about that more at the breakout session later today at lunch. Now, what I wanted to do was drill down on just one of these threats to give you a little bit of a better perspective on exactly what companies are facing and what their inside and outside counsel need to be aware of in preparing to deal with this evolving threat. And so in 2014, the Department of Justice returned an indictment in Pittsburgh that charged 5 uniformed members of the People's Liberation Army in China with hacking into American corporations and stealing their proprietary information. The indictment charged a variety of crimes, including computer intrusions and violations of the Computer Fraud and Abuse Act. These individuals are pictured on the wanted poster. They have not yet been arrested, but they are certainly well known at this point. Now, what the indictment provides insight into is the types of companies that are under siege. Listed in the indictment were a number of companies who had been victimized, who cooperated with the FBI. Companies like Westinghouse, SolarWorld, US Steel, Allegheny Technologies, and the types of information that was taken really sort of ran the gamut, from cost and pricing information for solar panels as it pertained to SolarWorld, technical and design specifications, and then internal communications regarding business and litigation strategy. Administrative credentials were taken, passwords were taken, and so really, the crown jewels of a company are of interest to any variety of actors, and that's precisely what was taken in this instance and as set forth in the indictment. Now, the other interesting thing about the indictment and what was included as an exhibit to the indictment, in addition to the pictures of the perpetrators, was a graph that showed when this conduct occurred. And you could match it up, sort of Beijing time, and what you would see is these uniformed officers showed up on Monday, activity spiked, dropped a little bit at lunch, went back up from 1 to 5, dropped off when they went home in the evening. That pattern persisted Tuesday, Wednesday, Thursday, Friday, down on weekends. And so, there are individuals across the world whose job is to try and hack into American companies and steal our information. So how is this done? Typically, or at least one of the primary means of committing one of these intrusions is through a spear phishing email. Spear phishing email is an email that looks like it's from an individual or a business that you're familiar with, the recipient is familiar with. It's not somebody that you're familiar with. It was designed to look that way. If you open that email and open an attachment, executable malware will be downloaded onto your computer. At that point, the malware provides unauthorized access to not just your computer, but to the network. It then beacons out to what's called a hot point, to a command and control server, where the bad guys operating from a world away can take their time, identify, collect, package, and exfiltrate data from your network. The time to detection is it's measured in months. So these folks will be in your networks for months before you detect it, and by that time, much of the information has been taken. Another threat that's been in the news a lot recently is that of ransomware. Ransomware is a strand of malware that will encrypt standalone machines, networks, in some instances networks and backups. And if you ever show up to your office and this is what shows up on your computer, it's going to be a bad day. This is CryptoLocker, a pretty common strand of malware that demands the payment of Bitcoin in exchange for returning the key to decrypt your information. Now, ransomware attacks are increasing exponentially. This quarter alone, and the first quarter of 2016, reported ransom payments were more than $200 million. You can imagine that many were not reported. Hospitals have been prime targets for this type of attack because the type of data that they possess is patient data. Often lives are at stake, and so they do not have a real option of not paying this ransom. So they are prime targets for criminals who undertake this type of attack. And so it is important, not just for hospitals and companies that operate in the healthcare space to be prepared for this, but for all companies to think carefully in advance about what they would do if this type of attack was perpetrated against them. So that's what we're up against from a technical perspective. Overlaid on that and adding to the complexity for companies and their inside and outside counsel are the three legal challenges that I mentioned at the outset. And those include cyber preparedness and regulatory compliance, managing cybersecurity incident response in a way that maximizes the protections offered by the attorney-client privilege and the work product doctrine, and then preparing to defend the inevitable post-attack litigation that follows a cyber intrusion. So legally speaking, OPE is not a plan. At a minimum, boards and management need to be engaged on data security and privacy policies. It is important to think about business continuity in the event of a cyber attack, to have plans in place, to have cybersecurity incident response plans in place, to think about cyber liability coverage, to think about the team, similar to what Lisa mentioned in terms of having a team ready to be deployed in the event of a government investigation. Similarly important to have a team ready to deploy in the event of a cyber attack. Again, these are a few points that should be part of any pre-breach evaluation of your cyber posture. Looking at legal agreements you have with customers or third parties, understanding what notification obligations you might have in the event of a cyber breach, understanding what cyber standards your partners are employing and what effect that might have on the security of your network. The Target breach, which was a well-publicized one, was conducted through a third party that Target had contracted with, an HVAC vendor. The attack was conducted through the HVAC vendor, who made their way into Target's networks through a network link between the two. Segmenting networks, segmenting authentication, and then the last 2 points here in the right-hand column. This goes to the sort of comparison I was making to Lisa's presentation, making sure that you have IT staff ready to respond and conducting tabletop exercises to test your cybersecurity incident response plans. These are simulations, hypothetical exercises where you walk through how people would respond, what you would do given a particular type of attack. Again, boards should be engaged well in advance of any type of incident. At the end of the day, I would submit that it's better to plan for a fire before it starts, and the same is true with respect to cyber attacks that can bring your business to a standstill. The other piece of preparedness is understanding cybersecurity-related regulatory requirements. Any number of federal agencies, state agencies as well, are getting involved in cybersecurity, and their agendas are accelerating. The SEC is in its second round of examinations of broker-dealers and investment advisors related to cybersecurity practices. They have brought enforcement actions based on lax cybersecurity. The FTC has been very active. The Third Circuit affirmed their authority to regulate cybersecurity practices as part of their ability to oversee unfair trade practices. And so given that decision, their agenda is only going to grow. Now, moving to the second legal challenge that companies and counsel face, when a breach occurs, at least three things need to be at the forefront of your thinking. The first is, how do we maximize attorney-client privilege and attorney work product protections? Often that can be assisted by employing outside counsel who can hire a forensic firm such that an argument can be made down the road in subsequent litigation that the investigation was conducted in anticipation of litigation. There are mandatory data breach notification requirements that need to be made at the state level, considerations about whether or not, if you have a public company, if SEC disclosure is necessary, if the event arises to the level of a material event, and then thinking through whether or not it makes sense to cooperate voluntarily with the FBI or with law enforcement in investigating the attack. There are pros and cons to that. Each instance is unique. It requires a sort of custom designed approach in terms of how to engage or whether to engage with law enforcement. Moving on to the third challenge, as you've read about, whether it's on Law 360 or the front page of the New York Times, litigation that stems from these types of intrusions is proliferating. And a question that is being addressed throughout the federal courts is that of standing. So if personally identifiable information of customers or of patients or of insureds is compromised, but there isn't any additional harm besides that with sort of future threat of fraud or some type of identity compromise, is there standing to be part of a class? The Supreme Court ruled this year in Spokio, not directly on that issue, but in a standing decision that interference with a statutory right or some de minimis violation is not going to be sufficient to qualify as a concrete injury. This decision has been used in multiple data breach class actions to try and defeat standing. There are, as you would expect, a variety of ongoing matters addressing standing. The majority position, which is articulated in this Zappos District Court case, is that there is typically not standing in these types of matters because the increased threat of future identity theft is too speculative. But buyer beware. The Seventh Circuit and other courts have found to the contrary that there is in fact standing. And when you think about a class that is able to proceed on that basis, it is certainly a litigation concern. And so I hope that has been a helpful overview of both the threat landscape and at least the three categories of legal challenges that we should be thinking about going forward in responding to this threat. So thank you very much.